What happens when law, business, and life collide? Each week on Lead Counsel, your host Tom Tona will take a deep dive into topics related to the law, the business of law, and life. There will be insightful discussions with industry insiders, experts, and thought leaders making significant contributions and meaningful differences in their fields of expertise. Tom is the founder and managing attorney at TonaLaw. He has been a practicing attorney since 1994 and the leader of TonaLaw since it opened in 2001. The goal of this podcast is to provide you with free information on law and the business of law, and to give you actionable tools related to each of these areas. Now, here's Tom.
Hey, welcome back to the Lead Counsel Podcast. Your host, Tom Tona. Before we jump into today's topic, I just want to take a minute to thank the sponsors of the podcast. This episode is sponsored by TonaLaw. They're not just another law firm. They're defining what it means to fight for their clients. We get a lot of attorney referrals from across the country. We pay fee participation in all jurisdictions where it's permitted. We focus on integrity, innovation, and relentless advocacy. TonaLaw is proving that the business of law can scale without losing its heart. If you want to see how a modern firm is built for impact and happy client referrals, check out TonaLaw.com. Mention again the Lead Counsel Podcast, and I'm happy to get on the phone with you. This episode is also brought to you by Meet Gabby, the voice AI built for law firms. Gabby answers your phones 24/7, qualifies leads, and books consultations so you never miss another client. Imagine cutting intake time in half or giving every caller a 5-star experience. That's the power of Meet Gabby. Learn more at meetgabby.com. Mention the Lead Counsel Podcast. You can also hit me up, and I'm glad to make an introduction to the owner. I am here with my good friend, Michele Fuller. Michele, what's happening?
Hey, Tom. Good to be back. Thanks.
Yeah, thank you for coming on. I was shooting you some text messages. I had seen some of the marketing you were doing. So this is your second time on. For some of the people that may not have heard the first episode, I've known Michele for several years now, right? Michele, we've been in that mastermind. And finally, one day I turned around and I said in the hallway, well, listen, you're super smart. I know you do something with PI lawyers. None of us understand what you're talking about. And so you took me out in the hallway. You were kind enough to explain it. But for the listeners, and there's a lot of PI lawyers that listen to this, explain who you are, what you do, and why it's important that they remember you if they hear this podcast.
Sure. One thing is I'm a probate and trust lawyer, but my focus is helping people with disabilities. So that means estate planning on one side, but I would say the majority of my practice is really helping trial lawyers create legal settlements that stand the test of time and provide justice long after the case is settled. It's really that in a nutshell. And I use different tools to do that, usually a trust, but I help keep lawyers out of trouble.
So let's drill down, because now I'm so glad that you got this in a way I can understand it. But I think what it pertains to is, you're about to settle a case, and what is the impact of that settlement for future benefits, eligibility, right? Is that what we're talking about, and specifically the planning that you're looking to do?
Well, it comes in a couple categories. So first, when we're looking at litigation, somebody has been injured. That is a universal that I work with different trial lawyers. Somebody has had some sort of injury and they have filed a lawsuit to get a recovery. And so sometimes they have permanent disabilities where they can't work. It may be related to the cause of action, but it may not be. It might have pre-existed. It might have existed since birth. That doesn't matter. So what I look at is how the money will impact this person from a benefit need standpoint, Social Security, how it will impact their income, how it will impact their health insurance, how it will impact other benefits like housing subsidies under Section 8, food assistance, and most importantly, their attendant care when they get in-home care. So I look at all of those things. And is that relevant to what you do? No, not necessarily. But I look at all these other factors to help assess how this money will impact their personal lives now and into the future, and how long it will last. Will it help them meet their goals? What are their goals? And so that's what we craft. There's no one size fits all. But before we even get there, on the bigger the case, the better the result, the earlier my involvement. So what does that look like? Sometimes you'll get requests from the other side about, I'm going to set up an MSA for a minor. It hasn't come up like that in a long time, but it still does. Or can you look at this release? Can you look at the motion? So we always look for ways to make sure that things go smoothly. When do you need a guardian ad litem? What court are you in? Are you in federal court or state court? So All I can tell you is that I help try and make things smooth, streamlined, support the client, help set expectations for what they can expect life will be like after their settlement is over, so that you can go on knowing that all the I's have been dotted, T's have been crossed, you're in good standing. You've done everything you can to make sure that that client, that their lives are made better from the efforts that you have undertaken for them. Justice is served. Is justice served if you just write them a check without any planning?
Right.
Eh,
Right.
you'll be lucky if it is. So there's a couple things. So what to look for first? One is sudden money syndrome. So I'll give you an example. I had a client who had some rough life after her husband was killed. She doesn't have any disabilities. She just had a really tough time and really struggled. So she knew that if she got $1 million in her pocket, it's not going to last very long. So what I created for her was a domestic asset protection trust. Do you care what kind of trust? What it does for her is creditor protection. She's never had a big pile of money like that. I don't know a lot of people that have that $1 million sitting in their checking account and know what to do with it. And you better believe that everybody she ever knew came out with their hand out. And so we created this management structure for her that was collaborative. So it didn't feel like, somebody's watching over her like a parent, but somebody's helping her make good decisions. And it has been a great relationship. So we set her up for success. And we did the same thing for her two boys, who also received a big pile of money. And that part had to be approved by the probate court because they're minors. But the minors are going to, what 18-year-old is ready to manage $250,000, $500,000? We call that a very good year.
Right.
So different types of trust for different situations. The idea is to make sure that, litigation attorneys that I work with work really hard. They really advocate for their client. They're spending weekends and holidays and evenings, which I don't think is what we're aiming for, but they do. They work really hard. And then what? It's gone in 6 months, a year. That's disappointing for everybody, right? And then they're calling you going, is there any other money you can go after for me? So that's that case, right? And that's not all that unusual. We just set them up for success, long-term success. So then there's the case where you've got people with health insurance issues, or disability issues like Medicare, Medicaid, and all the coordination of benefits and all the things that go along with that. So that's where special needs trusts come in and all kinds of other layers. So I think the idea is that when you have somebody in your office where you're like, this person needs some help. This person could use some help long after we're on in our next case. How do I make sure that they're supported? That's where we come in, right? To make sure that, we're checking to make sure that you're supported as a litigation firm. What does that look like? Can I help you revise your motions so that things go smoothly? 'Cause last time I checked, most litigation attorneys haven't looked at a trust since law school, or unless you signed your own estate plan, right? So that's where we help make sure that things are smooth as possible, that where there's maximizing the impact on what you provide. That's the long and the short of it.
So you mentioned an MSA before. Now I'm familiar with a lot of this stuff because I've had to, as the cases have gotten larger in my office, we're seeing a need for certain post-settlement strategy that, we had a larger settlement come down first quarter last year. And the attorney that was trying the case, who's an excellent trial lawyer, was like, listen, you're going to need an MSA on this, right? And I'm MSA. So you mentioned it earlier. Explain for anybody that's listening to this as if they were me, what an MSA is and, the current state of MSAs. Is it changing under the new federal laws that are coming down seemingly every day, that type of thing?
Sure. So an MSA stands for Medicare Set-Aside, and that's a type of account. So I think all trial lawyers are aware of liens, right? So someone gets injured, they receive medical treatment to help, with whatever caused the injury to get someone better. And then if they bring a lawsuit recovery and they do recover and medical expenses as part of that, then whoever has provided the medical services gets reimbursed. So those are conditional payments. Everybody, I think, knows that piece of things. But where there's a Section 111 under the Medicare, I forgot the name of the Medicare savings. Anyway, there was legislation, I can't remember the name, but that tried to help Medicare and prevent people from basically double dipping. So if you get compensated for future medicals and the person is on Medicare, you can't get your Medicare services paid for and have a financial recovery for that. So that makes sense from a logic standpoint that you can't double dip is what that essentially means. Medicare Secondary Payer Act. That's what it was.
Right.
So that basically means that somebody's been injured, they've received medical treatment, they've gotten compensation. Now, before you can completely wind up the case, if the person's on Medicare, you have to estimate forward what future medical treatment they might need that Medicare would cover and set that money aside. So what impacts that? What their condition is. You have to have the right ICD-9s and 10 codes to look at review and future treatment plans. So that is not me. There are specialists. That's all that they do. God bless them, is look at, medical codes. They look at past medicals, what the person's condition is, what they might need in the future, and they estimate forward. Do you have to have a perfect crystal ball? No. Where this comes into play, and I see it most often, is in the workers' comp field. That is mandatory, where you have to have one. If someone's on Medicare, you have to do a Medicaid or Medicare set-aside in that case. And it's for a very low threshold. So almost all my workers' comp cases have Medicare as part
Really?
part of the redemption orders. Yeah. So the tricky piece of that is that under the federal POMs or the federal policy programs, that Medicare set-aside account that can only be used for medical treatment is a countable resource for someone who's on Medicaid. It's countable. Now, under our state policy, it is not. Under the federal, it is. So it becomes a little more complicated, right? Where people have got this whole mishmash of stuff going on as far as like benefits, what kind of Social Security, what kind of healthcare benefits. And so that's where the 911 call is like, hey, Michele, what do I need here? Right? How do I set this up?
Right.
And that's fine. So that's where you need that all the time. Workers' comp, those attorneys, everybody knows MSAs, structured settlement brokers are really great in that context. Oh my gosh, they are a huge lifesaver. MSAs funded by a structure are fabulous. Now, who determines how much is set aside?
Before you even get there, in the third party context, how do you determine when or when not? Because I've heard really bad advice from lawyers, companies that do it. And I want you to set the record straight, barring any change in the law as it exists today. How do you know when, as a third party liability attorney, you need to inquire with an MSA provider?
Okay. So when it comes to MSAs and liability cases, what do we know is true? Is that there is no statutory mandate to create an MSA or Medicare set-aside in any liability cases. And in all of the legislation that has come through recently in the big, beautiful bill, there's nothing that affects that. There's no mention of it. There's no impact there. And so clearly the rules are the rules where you can follow the rules. However, there are some things that you can do to help protect your firm from future liability. So there is huge civil penalties for failing to protect Medicare's future interests. So what does that mean for you as a practitioner to bulletproof, at least as much as we can, your settlements, your resolution of cases that involve especially catastrophic cases? So are we that worried about like a small auto case where there's somebody's on Medicare and they're getting a third party resolution? No, not really. Where we're concerned is where someone has a catastrophic injury and they're on Medicare or in the application process. So where does that come into play from a benefit standpoint? Somebody who is on SSD, Social Security disability, and they have Medicare either pending or they already receive it. Now, the fun part is that when you ask clients, they won't know what they have. So this is where logging in, there's all kinds of professional organizations that will check and confirm like status of liens, whether somebody is enrolled, and what kind of Medicare coverage they have. Now, to keep it fun, there's kind of hundreds of different providers. And so this is where professionals that do this all day long are really key to add as a resource to the settlement team. So the long and the short of it is it's not required. But again, where we have future medicals, let's say somebody is catastrophically injured and they have 24-hour care provided in a skilled nursing facility. And they're like on a vent or something horrific where they need skilled care. So future Medicare coverage is going to be key in that case. So the worst possible outcome is that at some point Medicare shakes their finger and says, oh, you should have taken into account our prior, our liability, our future interests. You didn't to an adequate standpoint. So even if you do an MSA, are you going to get some sort of letter saying that you've adequately protected Medicare's future interests from the Center for Medicare and Medicaid Services, or CMS? Nope, it doesn't. You're not going to get anyone they won't even look at them. Right. So all you can do is document your file. So if you have somebody who is, and this is fairly typical, somebody has gotten as far as they can. Like as far as accident or injury related, incident related services, they're done. Get a letter from a doctor, paper your file. You may not need it, but you'll want it 10 years from now if somebody ever comes back to audit your files at any point. It's just about papering.
But it also sounds like there might be what you can do and there might be best practices. So if you have a settlement above a certain threshold, let's say 500,000, maybe even that's too aggressive, right? Let's say 350, whatever number you would pick.
I'm thinking large medical malpractice, multi-million-dollar recovery with somebody who has clearly on Medicare and will have a substantial need for Medicare services in the future. I think that's where it's worth at least investigating and doing a perspective, a possible allocation. And then this is where like I pull in service providers like National Care Advisors or a Massive. There's different lien res companies that are really experts in looking at those allocations to get them down as small as you can. So I've also seen a couple of things where that can be interesting on a settlement perspective. So sometimes having a really healthy set aside, or that you estimate that the liens are going to be really high, can help facilitate a higher number because
we always use them.
It's a strategy. It's a trial technique to help make sure that you are leveraging every aspect of your client's case to get the highest possible recovery. And then afterwards, once you get that, you kind of go, okay, now let's look at this allocation and make sure that we have the smallest number possible.
Right. Understood. And I think everybody knows that, right? Like you want to optimize what you're doing with the leverage on it. But then you're going to do everything you can to say, look, what's the realistic need for that set aside, right?
To be perfectly frank, I think that in my practice, what I see as a settlement planner is that I have not seen aggressive MSA set asides even for catastrophic claims because there's no rules. So if the number is, say, small enough where it really won't impact the client, get their buy-in and say, hey, this is just a protective measure. It's not required, and get their buy-in. And if it's a small number, it really doesn't make much difference, then maybe err on the side of protectiveness, right, to do that. If someone's looking at future Medicaid eligibility, though, it's going to be really important to make sure that MSA is not self-administered, which I've never seen go well.
Right.
I haven't. Now, have I seen any fallout from that? Not really, not in my practice, but is it possible? Yes. But I usually like to have those things owned by the special needs trust, right? That just puts a layer of protection. It's just another layer of administration that I like pulling in a professional to do because I don't sit there looking at ICD 9s and 10s. And because when they're paying out of that account, there's different levels of reimbursement. So the level of reimbursement under a workers' comp claim by a provider might be different than that as a Medicare provider. And you have to know which one. And also negotiate those prospective liens down or prospective costs down because, are you going to pay $5,000 for an MRI or $500?
Right.
So that's where, some providers will do it for free. Others will charge a fee. But the biggest thing to know is that a structure is a great way to fund it because instead of, let's say it's a workers' comp claim and we have to do one and it's a large injury and we have a $200,000 set aside because this person has catastrophic claims and Medicare is on the hook. Fine. So is it better to take $200,000 as a lump sum out of their recovery or have that buy a stream of income that will pay it out over their lifetime?
Right. An annuity, basically.
An annuity. A structured settlement is annuity. So just another little piece of the things is that if the Medicare set-aside provider who's going to administer that charges a fee that cannot get paid out of the account, you have to have a separate structure that pays their fee. So I think one of the higher fees that I've seen is $1,500 a year. It's a very small little structure that pays $1,500 a year that directly to the provider. So, but it's setting it up from the start, knowing that has to happen that way. So you don't want to make sure that you're leaving a provider high and dry, where you've got the right team in place from the structure broker, the analysis of the allocation, whether you even have to do one in the first place, whether it makes sense. And this is where, as a trial lawyer, my job, so I like to call myself a settlement architect. I'm not selling financial products. I'm helping to architect a settlement that will help protect you as an attorney and make you a rock star for your client, because the funds that you have fought for will actually make a difference to them in the long term. So that's what that's all about, is really setting up your team of experts that you can rely on to make sure that you can, one, know that it's being taken care of, and then two, you're going to go on to your next case.
Right. And you don't have to look back. You don't have to now pull the digital file and start combing through and reconstructing everything that happened.
Yeah.
Look, I'm very aware of it, and I've just tried to employ best practices since talking to you where, if there's an open question, I'll just text you or call you and say, hey, Michele, I just give me the skinny on what you see here, what you think is needed. But again, I do think it's helpful because even if it's a small PI practice, occasionally they'll have the one big case they land and it comes down. And then the last thing you want is to drop it at the last end zone of the case where you've already got the money coming in and you haven't really structured it properly for the client. There's a new generation of practices popping up every day. And so hopefully they hear this and they go, oh, when I get that big case settlement, I got some work to do. I call Michele, somebody like Michele, and really dig down on what I need to employ. We had a brain damage case where there was a large policy, very large. There was layers. There was a tower of coverage and there was a tender of all the money. And, I tried explaining to the family, like, look, you need some help. This was before I even knew you. And I called in an estate planning attorney. Yeah. They recommended a special needs trust. So switch over to the business side. I know I've seen some of your marketing coming out with the ticking time bomb that's in settlements, right? So explain the concept again and where the special needs trust aspect of it comes in.
Yeah, I think that there are some things that you don't want as an attorney, which is ever to get a complaint because you didn't adequately advise your client as to the impact that their settlement would have on their benefits. And so it's a key area of potential liability for an attorney. And that sinking feeling that you should have done something that you didn't, or you screwed something up, is horrible because you've gone out, you worked your guts out, you have this team, you have all of this, and it's all about helping people and help recover from an injury or something that bad that happened to them. And then there's this fallout. So it can happen on small cases, it can happen on big cases. And so the impact is real. And so what we do at the Architected Settlement Law Group, so I want to be really clear, I give legal advice, I don't sell financial products. So you tell me about that case. And the first thing I'm thinking of is, how many defendants are there, right? There's a brain damage case. Are there multiple defendants? Are you settling separately with each insurance company? So the first thing I think of is a qualified settlement fund. How do you fully settle with each company? And then how do you resolve liens in that case? How do you know how much you're dealing with? When do you do the MSA? So it's all about timing. So how can I buy you time? Qualified settlement fund. So each one of those insurance companies that want to settle, you collect the policy limits and you put it in a QSF until all the claims have been dealt with. All the insurers are done. In the meantime, we've been gathering information on liens, right? And we make sure that we talk to the client that the gross settlement that they're looking at is not what they're going to take home, and make sure we prep them for the liens, because the liens could eat up a significant portion of it. That's where the opportunity for more advocacy comes in by the litigation firm. And it doesn't necessarily have to be by you guys, right? The lead trial, because I look at you as a lead trial lawyer, a lead trial firm. And so that might be where you bring in a lit pro, a lien res company that goes in and you might need to advocate. And I will tell you, one of the impacts of this big, beautiful bill, there's nothing in there about Medicare Secondary Payer Act. There's no revisions to the reporting or CMS. But what we do see is reduced budgets for state Medicaid funding. So that means you're going to see higher liens. You're going to see more aggressive state recovery.
I was going to say at the state level then, got to get the money from somewhere.
100%. And they're going to be a lot less willing to negotiate. And so this is something to really be clear on as to what number, because everybody's got kind of a number in their mind as to what the client will net. And so in a case like a brain injury where you've got, or any catastrophic injury where you have a life care plan, what will this client need? Now there's life care plans that you need for litigation, right? To really make sure they're advocating for your client, every possible resource out there.
Right.
But in reality, what are they really going to need to make sure that they're not going to be made whole, but that they have a reasonable life expectancy and a reasonable quality of life? You need to get to that number somehow. And so you're going to have to reverse engineer it, and that it will drive numbers up. Clients' out-of-pocket costs are going to go up. You're going to see less coverage. long waiting lists. So for people that are going to depend on, I know you can't bring collateral sources into negotiations, but I think the reality is that as a special needs planner, I look at it and I go, okay, no matter what it is, we're going to try and make it work. And we're going to bring in as many outside resources through public benefits that we can. And the reality is kind of like the myth of Section 8 benefits, right? People have, I know in the Bay Area of California, there are waiting lists over 20 years long. Wow. So you may qualify, but there's no space, there's no bet, right? And so that may be what we see happening as budgets gets reduced, the level of services. So somebody may qualify medically for the services. They may qualify financially for the services, and there's no one to provide the service and there's no budget.
Right.
There's just endless waiting lists. So being prepared for that and not letting those collateral sources in is going to, again, drive numbers up, because the reality is the services aren't there. Right. So that's what we're seeing kind of happening with this big bill. And we're already kind of seeing the level of services starting to impact our clients.
Really?
Yeah, the providers aren't out there. And I know a friend of mine at National Care Advisors who is kind of our secret sauce for boots on the ground, hands-on, shepherding applications through, advocating for more hours, things like that. We're already seeing longer waiting lists. And even when you can privately pay for a nurse $75 an hour, $99 an hour for private duty nursing, you can't get anyone, even with the money there. So don't be too quick to settle. Right? Make sure that you've got all your ducks in a row before you do this. So the special needs trust is basically a framework for managing all of these private funds to be able to blend private dollars with public resources to the extent that they're available. And this is where that ticking time bomb is, for God's sake, don't have a family member as the trustee. They're going to want to do it because there's a control issue, right? They want to be in control, but they can't. It's really complicated. So everything that we've talked about today is something that all of these trustees have to know.
Yeah, I can't imagine a layperson. I can't even, as an attorney that doesn't do this, imagine I'm not going to be a trustee for anybody.
Yeah, it's a hard job. And unfortunately, I think, so the other tip I guess I have is for trial lawyers, when you're working with a probate and estate planner to do your special needs trust, there's some things to look for, right? And be careful, because you got to look at their expertise in this particular area, because it is tricky. How many have they written? How many have they defended? Special needs trusts. How many have they had to have gone through appeal and been successful? Do they understand all these rules? So you live in a no-fault state. I live in Michigan in a no-fault state.
Right.
When does the PIP carrier have to pay, and who enforces that?
Right. Yeah.
That goes on long after the litigation is over. So who's paying for van modifications? Well, that should be the PIP carrier, right? Depending on their coverage and what you've settled for.
How much coverage is there in Michigan?
It depends on their policy. So we used to have unlimited PIP for a lifetime.
That's crazy.
So that is still an option under coverage. So a lot of clients don't understand, just don't go cheap. And I swear the people who are selling auto policies are encouraged to sell the cheapest policies possible.
Of course. Well, they don't want that exposure on the back end.
Yes, exactly. Because it's unlimited, right? Depending on their choices. So
that's crazy. Like New York has a 50,000 cap. There is a PIP available. We've seen as high as 100 maybe, or 150 additional PIP, not ever unlimited.
Lifetime unlimited is available as an option. And so we call that, they affectionately call it lawyer coverage. And that's what I have.
Right.
And does it impact my premiums? Yes, but not as much as you'd think.
Right.
Yeah. So the worst selection that people can make, which I occasionally see, is that Medicaid will cover.
Right.
Well, that doesn't work out so well.
Good luck with that. Yeah.
But if you can afford it, if anybody's listening, make sure you look at your client's coverage. If you're whatever is a screening tool, no matter what kind of case they are coming through your firm, look at their coverage and make sure they have uncoordinated, underinsured, if they can possibly afford it, and unlimited PIP. In Michigan, choose unlimited PIP, please. Always, 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 because you're still going to have to fight the carriers to make sure that they're paying the coverage that they should. But I have catastrophic claims that were grandfathered in when it was unlimited PIP for a lifetime for everybody. And occasionally the insurers will want to settle all future PIP claims. And you better have a life care plan. You better have an economist and know exactly what that looks like. And sometimes that actually ends up really good for the client, because we put that in a special needs trust and we aren't fighting an adjuster to get paid.
Right.
The money makes money. So one of the ones that I was involved in, that was a $12 million net payout.
Wow.
And that's for a lifetime of care for a kid who had a TBI, and he'll never be the same. So that is for a lifetime of care. And that is about right. So
Right,
those
right,
are
right.
out there.
And those are real numbers, right? Those are real
Yep.
numbers where you can understand the incentive of the carrier. Clearly, it's to save money and not have that open exposure. But done right with somebody like you doing that planning and the right instruments put in place,
Mhm.
that money will last. I mean, that's basically what you're talking about. Quick break to thank Meet Gabby, the voice AI that answers your phone, screen leads, and books consults 24/7. They'll even send out retainers if the person on the other end of the phone asks for a retainer. If intake is slowing you down, check out meetgabby.com. This episode is supported by TonaLaw, a modern law firm built on integrity and innovation. Learn how they're changing the game at TonaLaw.com. Attorney referrals accepted from across the country. You'll see what it's like when you send us a case. You'll have some happy clients. One of the reasons I wanted you to come on too is there's so many people in the rooms that I am in, you're in, that we're just doing business every day and they don't understand this stuff. I was one of those people till I became friends with you and I really wanted to have a deeper understanding of what's at play. And thank God I did, because you find yourself at the end of the largest case in your office. You should know this stuff, or at least know, I heard this person on his podcast, this is a multiple 7-figure number. I
Mhm.
need to get in touch with Michele before the money comes in. And as early as possible, hopefully. But if not, at bare minimum, you're walking out of court, you say to the client, listen, we got to get somebody else involved in this. I'll
Mhm.
keep your costs as low as possible, but we need to do some planning. This money
Yeah.
has to last you, right?
So the way that I charge is a very small percentage of the net, because my service has to do with really probate and estate planning, right? It's settlement planning, but the legal architecture of what that looks like. So just like you start, you don't start your trial prep, a month before trial.
Right.
Right. You're building the theory of the case as soon as it lands on your desk.
Yeah.
And so you should be building toward the end the same way.
Especially if you know that you got a large policy with a catastrophic injury. That's the real sign right there, right?
Absolutely.
And then if you know it's a case, because we know early on, look, there's going to be a lot of liens involved, right? You just know, you can tell if it's a premises liability case or whatever, there's going to be larger liens. And so that's where you start to do that calculus and throw it into your planning, right? As a
Yeah.
lawyer.
Absolutely. So the way that I bill is basically one flat fee. And so the client will know it's a percentage of their net. They don't even have to know what they're going to net, because the value that I bring is to the planning is the long-term impact on them, not how I get there. So if it takes 2 different trusts, if it takes multiple court proceedings, and when does that start? It starts as soon as the engagement is agreed upon. That means that as things come up, I'm on the team, right? I'm part of the litigation team. So that can go from even smaller cases where you're like, listen to that little alarm bell, where you're like, if there's anything you're worried about, you kind of go, there's something about this case. I might need some help on this to make sure everything's done right.
Right.
Is there any additional cost to that? No. So that's where the client starts building trust. Everybody's a little bit different. So I've been involved in everything from my clients. This is a minor, the kid's getting was bitten. It's a minor thing, or they had a really minor injury. They fully recovered. What do I need to do to stay out of trouble? I got $5,000. What can I do with it? Right. All the way up to 5 million, a billion.
You worked on specifically, and I know this because we're friends, but you worked on the Flint water cases, right?
I did the design for that settlement.
That was big, right? I mean, how big was that?
That was a $600 million settlement. I was brought in as an independent expert by the state, and I had to coordinate across 4 different court systems: federal, state, court of claims. So that's basically a court of appeals, and then the local probate court, and then create a streamlined system for really allocating and managing funds for 10,000 injured minors.
Oh.
All lead poisoned.
Yeah, I mean, I know that was big with the mass tort firms, or the environmental firms, I should say. I know a few of the firms that were doing it. It's funny because I have a friend who does that stuff, and I'm always texting with him, and he's like, oh, no, I just hand that stuff off at the end. I don't get involved in any of that stuff.
Yeah, and that's great, because that's my objective, is to be able to give you the confidence to do that. We can communicate, give you, keep you in the loop, because you should be in the loop, at least to understand what's been going on. But otherwise, the idea is that you're supported through litigation, it's done well, done right, and that you look great with your clients because you care about what happens to them after. I see this a lot where, hey, so-and-so got me an $800,000 recovery. I was hit by a truck, but how has it made a difference in your life? Or did you declare bankruptcy?
Right. And look, I tell clients, especially on the bigger ones, a couple of things. A, don't discuss it with your family or friends or anything. Then you always have a fallback. You could say, oh, my attorney is doing something on it, right? Or said, no, I can't talk about it, or something else. But I also tell them the cautionary tale of the studies that have been done is regardless of the size of the settlements, they're gone in like 2 years for almost every personal injury client, which is just, like, especially if somebody needs the money, needs it for prosthetics, needs it for whatever, you got to make it last. So I do feel like it's incumbent upon the law firms that are trying to do the right thing by the clients. And there is a sector of law firms that really just doesn't care. They're going to settle the cases, cut the checks, and move on. And they don't care about the future. They worry about the right now, But if you really care about the outcomes for the clients, it's always best practice to, like we've said in the past, I'll say it again, is look at it like a team approach, right? Bring in an outside lien vendor if liens are going to be extensive and need negotiation. And then as far as the future planning of future benefits, and you said it perfectly, which was it's a coordination between public benefits and public funds that are available to optimize for the client the outcome. You don't want the settlement at the sacrifice. And I've had clients tell me like, hey, I do not want this to affect my Medicare. Right. And I go, okay, well, then we need to look at an MSA, or I'll call you up and go, look, Michele, I know what the rules are, but I still think best practices is XYZ, which is, making the inquiry for the MSA company. You know what I mean?
It's really tough because a lot of clients, when they're coming to you, something has happened, something bad has happened to them. So they may not be real clear on what their benefits are, how they qualify. A lot of times you'll ask a client, like, what kind of income do you get? And they say Social Security, disability. And then the conversation ends there. I have to ask, what kind? Right. How do you qualify?
Right.
There's different ways. There's a gazillion different ways that's a little overstatement, but a lot of times people are confused.
Don't make me nervous. I only know a handful that I know I got to check for liens when I'm talking about liens with clients.
But you see what I'm saying is like you are, and trial lawyers, as they should, are looking to build their case, to assess and then build a case if it's a good client and they take that on. For me, I'm looking at I'm looking really at the client and more holistically. Like I'm going to dig into how they qualify. When did things happen? When did their diagnosis start? And it may not be related to the injury that you're litigating, but that all impacts the tools that we use, how it will feel. So that's one of the reasons that I started my nonprofit advocacy 20 years ago. I can't believe it's a 20-year anniversary now, but
wow, I didn't know that. So talk about that, because I don't know too much about the charity. Talk about it.
Yeah. So what was really frustrating to me is that here I do the planning. I stand up this gorgeous trust, right, that is going to run a certain way. And the most important thing to a client is so under a special needs trust, the person with disabilities cannot be their trustee. They cannot be their own trustee. And we've already talked about it's a disaster when family members are trustees. So they're going to hand it off to some stranger, every penny that they have in this world, and trust that they're going to get what they need. Right. And so I'm creating a promise to them. I'm drafting this very complicated document that they may or may not understand. And then I'm handing off the responsibility of who they're going to interact with for the rest of their lives until hopefully the money outlasts their life, depending on how much it is. And I'm promising them how it will feel, what they will experience, how hard or how easy will it be? What rules do they have to operate under? And I was chronically disappointed and getting nothing but negative feedback, no matter who I handed it off to. So I have a couple of really trusted resources for smaller cases, but for larger cases, like $500,000 and up, I created this nonprofit to be able to do it because there was no other way I could fulfill the promise that I'm making to people that would be done the way I wanted it to. So there's a couple things, like we have a collaborative relationship with the beneficiary and their family, their trusted family members. They have a significant role to play in helping make sure that the trustee is advised, especially if the beneficiary can't advocate for themselves. Family and friends are critically important to make sure that we know what is going on with this person or what they might need and how to protect them. And when things go sideways, we have the resources to bring in? Like there's a 911, somebody's caregiver didn't show up, whatever. Oh, the PIP carrier should be paying for this. It shouldn't be coming out of the trust. And I've had to go litigate, and I don't litigate, but I get a good, really great litigation firm, right? To go sue the PIP carrier because they aren't paying what they're supposed to pay.
Right.
So The long story short is that I want to make sure that the family or the beneficiary is supported long after you guys have gone on to the next case, and that they are nothing but grateful for that interaction, that they feel taken care of and supported. And so that's why I did that. And we've only just now opened it up to other practitioners. So if you're listening and you've got your favorite trust and estate planner, I don't have to be the attorney on every case. We can certainly collaborate and make sure that the trust is stood up. But if you need your client to make sure that they are being well taken care of, that the promises that you make and what they're going to experience are met, that is really important to me, to be of integrity and a person of your word.
And that's through your charity, which is even awesome that you're putting that together. And so the charity, though, they act as the trustee?
Yep.
Okay,
Yep.
awesome.
It's called advocacy. And there's also, I've been doing a lot of consumer-oriented webinars. So if your client is confused about SSDI, because they come to you guys with all the questions, right?
Yeah, for everything. And
so
you got attorneys, especially, we've had younger attorneys in the past, not so much now, they're much more experienced, but we've had some younger attorneys in the past where they're like, what the hell are you talking about? SSDI. Now, I came up kind of understanding all of the lingo. And again, because I tried cases, so the other issues that come up with the collateral sources, which turn into future sources if they were involved at the lien stage, right? So I think it's really important. And you've always been an awesome resource for me. You're like a text message away. You give out your cell phone to everybody who's a lawyer and you go, listen, if you need me, just text me, which I do all the time. I feel like I text you a couple of times a week, but it's super important. And I feel like, just as an example, a lot of PI firms, and maybe they don't care as much as, you said something really important. You want to fulfill a promise. People weren't happy, so you were going to do something to fulfill that promise. And I practice the same way, which is why I think we're in the same type of mastermind together, right? And I appreciate that. Like, we had a client crossing a crosswalk. She got hit in the Bronx and she had a very significant settlement, and workers' comp was involved because she was going to her car to get equipment. So there was a workers' comp lien, but she had PIP and APIP. So after the case was over, we paid the comp lien. They reduced it down. I want to say it was like whatever, very significant comp lien that they reduced down a little bit, but we paid it. I then sent it to the other side of my office and did exactly what you're talking about. And I went after the PIP. I said, hey, I found this statute. We've got a priority of coverage issue here. You should have paid this. You didn't. We had to pay a lien. We got that money back, but we had to litigate that lien claim for 2.5 years. Finally got a call from the partner representing the PIP carrier who said, we dropped the ball. This is on us. We'll settle the case. And they ended up paying over and above because of the lawyer's fees involved.
Yep. Those are definitely issue spotting, going after it. You're a litigation firm, go, right?
Right.
That's the importance of making sure that you have people on your team that can either issue spot that, bring in good litigators to help advocate even well after the fact, bring you back in. I mean, we've been working on a case for 7 years, and the litigation attorney, we've been fighting with the PIP carrier for 7 years.
Wow.
And so finally what we decided to do is just say, you know what, this kid, catastrophic injury, we're just going to pay for what we need to, and then we're going to go sue the crap out of the PIP carrier because we're tired of dealing with it. And the family was dealing with it. The PIP, the lawyer was going after him. And I'm just like, you know what, we've got the money, let's do it. And then we'll deal with the PIP carrier later. But you actually brought up a really interesting point, which is what happens when you go through an appeal? What happens when you go through, or you've got a case with punitive damages? So this is something that's kind of a newer development in that, for instance, I have a case where this gentleman, he had a personal injury cause of action, and it's been in an appeal for going through the different appeal process for over 7 years. The initial award of, I think it was 5 or 6 million, it was for bodily injury. So that's obviously tax-free, right? And I'm not a tax guru, but
pain and suffering, right?
Pain and suffering. So we got all that. So tax-free. But because the appeals period has been like 7 years, the accumulated interest is over 2 million. Wow. That is taxable. That is taxable.
It's interest, because it's statutory interest.
Yep. So what do? Is there something we can do? Because what will happen is that the client will get a 1099 for that full 2 million. Oh my God. They're going to net at best half of that. And then their tax bill will be for the other half. Because their tax bill on that's going to be what a rough estimate would be half of that.
Right.
So they're going to end up zero, or at worst negative. So
on the $2 million in interest you're talking about, they don't get that tax bill unless the appeal's decided, though. You're not talking about
right,
they're not
right,
getting a tax bill mid-appeal, right? Okay.
right, exactly. No, after it's paid out.
Right.
So what can you do? So I work with Eastern Point Trust Company on this. They have something that's proprietary, I believe proprietary to them, which is the Plaintiff Recovery Trust. And anytime you have punitive damages, taxable recoveries, so property claims, environmental cases, anything that's a taxable event for your client, the worst part of that is that attorney fees are not deductible.
Oh, so they hit him for the whole thing.
The whole thing. And so they have this plaintiff recovery trust that basically there's a timing element that's crucial here. So if you have something like that pending, timing is of the essence because there's a substantial tax mitigation for your client that's available, and it's key. So what would happen if they find out later that you should have done something, could have done something, and you didn't?
They're coming back to you. They're coming back to you.
They're going to come to you for the millions of dollars in taxes that could have been saved. So be careful of that. So what are we talking about? Taxable recoveries. So punitive damages, so roundup cases, the Alex Cross case, the punitive damages well outweighed the actual bodily injury award. So you have to be careful, especially on appeals, large interest rates. Now, there are some exceptions where sometimes they've even legislated away that issue, but so far that is the case. So you just have to be really careful.
Yeah, that's...
So
every time I talk to you, I feel like I'm not going to sleep after because there's so many issues that come up in the future. Thank God I got you on speed dial, though.
Yeah. The thing is that when you have a settlement planner who's an attorney, I'm listening for those pitfalls. When you tell me about a case, it's not just about the person that was exonerated or a person that you did this and you're in an appeal. I'm going, okay, so you're in an appeal. How long has it been under appeal? Okay. What do you think the interest is? Oh, okay. So I'm listening for issues. So like when you were telling me you've got, this case where you've got multiple defendants, you've got multiple liens. So this is where there are strategies that, again, they have timing elements. So there might be a qualified settlement fund. So I know with all law firms, with all businesses, cash flow is always an issue, right? So when you have that, a qualified settlement fund allows you to settle with each defendant. You get paid, and then you have time to work out the liens. You have time to prepare for litigation or really just strenuous advocacy. In the meantime, you're not waiting to get paid. Right. And so you're bringing in, you may have outside experts that come in. And I would want to caution you, look at your ethical rules under your state and look at your retainer agreements or your engagement agreements, because what are you promising? When was the last time you looked at it?
Right. Well, you know what's funny? I have an ethics guy on retainer with my firm. I either did a post or I was preparing a post on LinkedIn where I was like, the sum and substance of it is this. The bar associations in New York have failed. The local ones in Suffolk County anyway have failed lawyers. And to the extent that in other states, they have an ethics hotline. You call up, they pick up, and you get an answer, or you send an email, you get an answer in writing, right? 3 years ago, I called my local bar association. I'm still waiting for answers. So no, I'm not joking. So I have had to pay tens of thousands of dollars a year for the type of stuff that we're talking about. But I was saying, I brought that up to the extent that we are looking at my retainer once a year as the practice evolves, as all these nuances start to come to the forefront, or the federal government closes a loophole in the MSPRC Act, and all of a sudden that loophole is no longer there, right? So now we have to make sure we're covering for all of these different things. And I do think that'll come, by the way. I do think that at some point they're going to close that loophole on MSAs and all of that stuff. It's just a matter of time.
I think it's coming. I think this is where making sure that your claims are properly reported and you're covering your butt. Right. Paper or file. But I think, having an ethics attorney on retainer is pretty unusual, Tom. I don't know anybody that's looked at their retainer agreement every year to make sure that they're understanding exactly what they're promising.
I'm hyper aggressive. You know me. So I'm hyper aggressive with the marketing. I'm hyper aggressive with the way we litigate. I'm hyper aggressive with AI and technology, right?
Yes.
So as this stuff evolves, I'm double checking to make sure that I'm at the forefront of compliance with AI. So you'll see different disclaimers on our website, on our social media, all that stuff, which I would never think of other than if you're going to be aggressive in marketing, you better be making sure that you're allowed to say what you want to say, or that your marketing people want to say, right? So I've literally had an ethics attorney on retainer for probably the last 5 years.
I think you're the only one that I know that I could say that about.
Well, no, I know one of our joint friends down in Florida, he's got a local ethics person. And some of the people I know, like they'll use them project based. They say, oh, I want to run this ad campaign. Let me get an opinion letter. Right.
Or trust in estates lawyers, which is basically probate and estate planning.
Right.
We don't do that, but we don't advertise on TV like you guys do, right? The plaintiff lawyers or trial lawyers in general are different in how they market, what's acceptable now that we've got, 20 years of Morgan & Morgan everywhere.
Right. And the market's gotten so hyper competitive that the marketing people want to get more and more aggressive. So then you need to be double checking everything that's being done. And it becomes almost untenable if you don't outsource it or end up big enough where you could have it in-house. Right. You have one person who handles it.
But I think this is where I have to congratulate you about being a thought leader, like a thought leader on the use of technology to leverage your staff so you can provide better service to people, have a smoother experience for your team, make sure that no stone goes unturned. And this is part of that compliance where you're looking at your retainer agreement. What am I promising my client? Am I promising that we are doing the probate, or are we segregating that out? Because we are not experts in that. Same thing with tax planning. Are you promising to do that? Or are you saying, no, we're going to exempt that and we're going to bring in an expert for any kind of benefits or tax planning? What about lien resolution? Are you exempting that? And so just really clear on what you do and what you don't do. And so you don't have to take on lien resolution.
We don't. And then if at the end there's going to be efforts made, then we're going to either outsource it or we've got some people on the team now that are like, listen, we can get this one wrapped up relatively quickly. No sweat. I want to do this for the client. Right. But if you have a voluminous amount of liens or anything else, I can't think of anything worse than trying to do it in-house. Right. Like it's just because again, and most law firms don't want to do it because they're not getting paid for it, but they'll do it begrudgingly if they didn't carve it out in the the retainer. So I think that, look, we can probably end it on that, which is if you have not looked at your retainer in several years, you should probably do that. You'd be surprised how much it's changed. The requirements are constantly changing. It's on you if you don't keep up with them, right? So, Michele, thank you so much for coming on. It's always a trip that I actually enjoy talking about this stuff, but I like learning from somebody with your level of expertise. You have been an invaluable guide on post-settlement stuff, even pre-settlement where I'm like, hey, I got these issues coming up. Can you just give me some guidance through it, et cetera? So I really appreciate it. I know the last time you did this, you got contacted by several large companies that needed your expertise. So hopefully people do find value. It's weird how this podcast takes on a life of its own. I got in an elevator. I was at Fireproof, Mike Morse's summit, which by the way, I'm like, you should have a table there. You should have a table. No, I'm serious. There are, I forget how many hundreds of PI firms that were at this thing. And Mike Morse is like the local celebrity in Detroit, right?
In my backyard. Yeah, that's right. I know him.
It was crazy. I mean, every billboard has his picture on it. So I get in the elevator and some guy who's across the country is like, oh my God, I listen to your podcast. I've been binge listening to it, right? So you'd be surprised the reach that what I like is it connects people. If they're listening to this, they're kind of like-minded like us, where they do want to do cutting edge. They do want to do above and beyond for the clients. And so hopefully they now consider you a resource because the issues that are out there, even when you think you're in the end zone on the settlement, I always like to tell clients, we're only 75% of the way there. I still got to look at the liens. I still got to look at the future benefits stuff. And I'm trying to get that word out there. Like our mutual acquaintance that does the marketing for us, I did a complete marketing push around informing clients about liens. It's all over my website. It's all over my social media because I wanted to make sure our clients knew the resources are there. We understand what's going on and they need to understand it, right? Yeah. They need to understand a gross settlement versus the net settlement, which you used. And it's funny. I'll give you another, for instance. I was talking to my team today. I was at a networking meeting 7 o'clock this morning, and I'm fairly certain we're getting a referral of a very significant personal injury case because the client has no idea about the form letters being sent to them that are advising them about depositions. And I'm like, we have to do a better job even on our form letters, right? Depositions are run of the mill. Every attorney goes, yeah, we know what depositions are. Your clients don't know what an EBT is.
Nope.
Right. So
they don't.
the landscape of what we all do is changing so fast, and the competition is so fierce that if you're not at the cutting edge, you're pretty much guaranteed to become extinct. You're
I couldn't agree
guaranteed.
more. I will
Guaranteed.
tell you, in the estate planning world, oh my God. I mean, AI,
I
document prep,
know.
you
I
know, so
know.
it's all about service. And I think that really marketing to a client, it's not just that I got $800,000 or $1 million in a car accident and it made a difference, right? And
Yes.
so all these little things that we're talking about
Yes.
today, which is making sure that we're maximizing our, not just maximizing, optimizing the result for the client long-term will reflect on you, that you are a firm that actually cares about the results, not just that you handed them a check, you gave them a resource that supports them for life.
Yeah.
And that's where we come in.
Listen, you are taking words that it's like you listen to my conversation with my team today. I said, look, marketing is getting them in the door, but it's also marketing keeping them in the door with great client service, great client communication, and great results. It's a 4-part formula, right? Get them in the door, keep them in the door, communicate, give them care and love, and never stop communicating. You get a great result. Tell them why it's a great result. And tell them what you're going to do to care about them. Now that the result is ready, there's other stuff that has to be done to continue to care about them, is what you're talking about. So I love that. That's why I love being in a mastermind with you, because you are a thought leader on so many fronts and you're doing such cool stuff that I'm finding is a tremendous value add to my practice. So I want to thank you.
Thanks,
I think
Tom.
it's amazing. Thank you, Michele.
I have to tell you, there's one story that really meant a lot to me. And I got some feedback from a trial lawyer that I really respect. She's a thought leader, outstanding trial lawyer. And we were in the post-mediation. Now, I don't participate in a lot of mediations, but I did in this case. It was a catastrophic injury. And the person who was injured had mental capacity. They participated in it. We were dealing with some really low caps on med mal. It was quite a blow to them that they had a certain picture in their head about what they were going to be able to take home. And he was really reluctant to settle. It was a good offer. It wasn't great, but if we had gone to trial, the result would have been maybe 100,000, maybe more, because of the caps. So in the meantime, we know as the litigation attorney, she very clearly spelled it out. The longer we go, the larger the liens, we're going to have a ton of costs. Your take home is not going to be much more than what you would do now by settling, and you're going to get it now versus years from now. So he was having a really hard time with it. And so we talked a little bit, and I just talked about, okay, instead of focusing on this terrible thing that happened to you, that wasn't your fault. Yes, it was a horrible thing. Let's look and see. So we changed the conversation to what the future could look like and all the things and how this would make a difference. What are we going to do first? What's your biggest need? And we started talking about the future. And then he got excited. And he was actually kind of like, oh, okay. So it wasn't just about making this decision and being afraid to make this decision. It was like, oh, okay. And this is how it makes a difference. And after we were done, she said to me, you deliver bad news the best I've ever heard anyone.
But listen, as you were saying it, because I've had this idea for a book, and I think that what you did in the story you just told me was you turned somebody who felt powerless as a victim into having a measure of control over the outcome in the future, right? And that's all clients want. I have an idea for a book, so I was not going to finish it with what I was about to say, because I've been marinating on this idea that I try to figure out what my clients feel. And I think that most of the time they feel extremely powerless.
Yes.
And what they want is to feel like they have an advocate. And what they really want is to feel like they have some modicum of control over the outcomes in their life. Not great news.
Nope.
But gave that client control over the outcome. It was not going to be like, oh, you're getting $10 million. It was going to be, we can take this money and put it to work and use to provide for you, right?
Yeah.
In a certain way that protects it and shields it from creditors and all of that stuff. So I love that. I love that, because that's what clients want.
Yeah, something horrible, life-altering happened that will never change.
Yeah.
That is what it is. It happened, and he will have to live with the outcome of that. There was no getting away from that.
Right.
But instead of fixating on that and dwelling on that, let's turn the conversation to this other area. Let's talk about the future and what this could do for you and what this life will be like. Right. And we talked about that, and it changed the entire demeanor. It changed even how he felt about the litigation. And because the litigators did a phenomenal job in this case and really weren't getting the credit.
Right.
And so this is where, no.
And that happens a lot. Look, that happens a lot. Very often we are the brunt of the frustration that the client feels. And I try to tell people on my team, like, look, you have to rise above the reflex to argue that, right? Because they're telling you how they feel, and very often is misplaced. They don't know the lengths we go to get them the right outcome. But that's also incumbent upon you and your communication with the client. Like, let them know everything we're doing. Let them know how far we're willing to go. And the fact that they do have some control over the outcomes. You just have to look for where they can control. They can't control everything. No one can. No one can control everything, right? So
exactly. Leaving them with hope and a look to the future. What's next? And so I think that's a big deal. And I have to say that there are some mighty fine lawyers that I've been really, really privileged to work with, that they're emailing me motions on a Friday. They're working on a Saturday. They're doing trial prep and they're not showy about it. Some people it's kind of cool to see. Sometimes they'll post on social media, like what they're doing, what it takes to prepare for a trial.
Right.
But most of the time, they're quietly working in the background, doggedly, and just working miracles for people. And this is where I try and give kudos where I can, because they are achieving extraordinary results for people. And the last thing I want to do is see it last a year. I want to see it last the rest of their lives. And so this is where it's that team effort, right? And that's why I call it the Architected Settlement Law Group, because we are architecting their futures. We're ensuring justice that you have helped to achieve. So it lasts well beyond the courtroom.
No, I love that. I love that. On that note, we're going to end it because I think there's nothing else to be said. Like, I love that. And I love that you want to help the same clients that we want to help, right?
Absolutely.
So thank you, Michele. Thanks for all you do.
Thanks for having me. Really appreciate it. Thanks, Tom.
Thank you. Thank you for listening to this episode of Lead Counsel Podcast. Your host, Tom Tona. Go anywhere podcasts are distributed. Follow us. Leave us a 10-star review. Share some episodes with your friends. And thanks for listening. I appreciate it. Thank you. This episode is sponsored by TonaLaw. They're not just another law firm. They're defining what it means to fight for their clients. We get a lot of attorney referrals from across the country. We pay fee participation in all jurisdictions where it's permitted. We focus on integrity, innovation, and relentless advocacy. TonaLaw is proving that the business of law can scale without losing its heart. If you want to see how a modern firm is built for impact and happy client referrals, check out TonaLaw.com. Mention again the Lead Counsel Podcast, and I'm happy to get on the phone with you. This episode is also brought to you by Meet Gabby, the voice AI built for law firms. Gabby answers your phones 24/7, qualifies leads, and books consultations so you never miss another client. Imagine cutting intake time in half or giving every caller a 5-star experience. That's the power of Meet Gabby. Learn more at meetgabby.com. Mention the Lead Counsel Podcast. You can also hit me up, and I'm glad to make an introduction to the owner.